My name is Stu Faith, and I'm here to talk about the virtual practice of law. This presentation, in part, is based on an article that I wrote for the Maryland Bar Journal, which is available now on the MSBA's website. So I will post that in the nearby chat here. So you guys are welcome to take a look at that publication. You can look at the PDF whenever you care to. And as I had mentioned, in spite of the technical difficulties, I am actually streaming this. So if you are having trouble hearing me on SL Voice, in theory, you ought to be able to hear me on my personal stream. At least 25 of you at a time can do so on the stream. And I'm going to go ahead and record the stream and just sort of see the quality of that after we're done with this. To see whether it's worth reposting this or not on our website after the fact. But if you, during the presentation, if you have questions, feel free to post them in local chat, and I'll try and get them and respond to them, no problem. The topic today is to first kind of explore a little bit what it means to be a virtual law practice or a virtual attorney. Talk about some of the technology that's available today that is relatively low cost that would potentially help you. And then I wanted to talk about some of the legal ethics issues that I think this presents maybe uniquely or differently than perhaps the traditional law firm legal ethics issues. And so I have those things as a part of our discussion today. So let me get into this. So I'm a solo practitioner. I've been practicing for about 6 years now here in Maryland. I do business law, estate planning, and some intellectual property work for clients. I'm the current president of SL Bar Association, and you may get messages from me periodically as we put on other presentations or have other events here. So that's the reason why. It's because it's me, the bar president. I also, this year I'm teaching full-time at the Community College, Baltimore County. I teach business law, legal writing, and next semester I'll be also teaching torts in the legal studies program there. Back before I was a lawyer, I worked in IT for about 10 years. I worked at a health center as the IT director. So it was kind of... It's always been interesting to be in SL because SL is kind of a technology thing, but I'm here really as an attorney, within the Bar Association. But it's kind of an interesting mix of the two. So I guess definitionally there's a question, what is virtual law in the first place? And I think people actually disagree about this because it's relatively new. There was an article I read that was written about 10 years ago that suggested really all virtual law is individual attorneys or small practices that get together and they use like teleconferencing and they use the internet and other things like that in order to present themselves as though they're a bigger law firm. So it's a sort of a virtual firm. And, so they'll work together and they can take on bigger clients because, big clients want a big law firm, but they can compete on price because they're a smaller firm, they have less overhead, they're just sort of collaborating, together for a particular large client. So that was in like 2004, 2005. Is one perspective on what it means. And I think that's basically just a bunch of traditional law firms that happen to use some technology to work together, maybe just for one client or maybe for a string of clients, but kind of really primarily a traditional law firm. In recent years, there have been a variety of service providers that have started to offer these online platforms where you as an attorney can sign up. Sometimes you pay a marketing fee or some other fee, And then the service will actually send you clients that have needs, and you can interact with them, maybe evaluate whether you're the right attorney for the matter, and then they can evaluate whether they want to hire you or not. And then sometimes there's fee sharing, which has its own legal ethics problems. Sometimes it's just this flat rate marketing fee. You typically, as an attorney, sign an agreement, and there's a question of whether that agreement might impact your independent legal advice or not. Again, an ethics issue. But it's sort of virtual law in the sense that you can have a lot of clients that come through a process like that. The marketing is really handled by the platform. And a lot of the interaction is electronic, either through the hosted website itself, or maybe you have some other a way of electronically interacting with the client, maybe more traditional like email or teleconference or something. And so there are some examples of that. Avvo actually has started to do this as of late. They're building up a network of attorneys that can respond to legal requests through their website. Rocket Lawyer is another example, and their model's a little bit different when I looked at it. It's sort of a more ongoing relationship, and there's some expectations about your responsiveness, to when requests come through and so on. Another definition that's offered through the ABA is when a firm uses technology to provide one or more kinds of legal services efficiently, but also that the way that that's done is by dealing with the applicable legal ethics rules, so that you're in compliance with those issues. So that's not really the same. It's not that you then become part of Avvo or become part of Rocket Lawyer, but you yourself have your own platform under your own firm's control, and that you're actually responsible. Or you and the service provider are actually responsible for dealing with the legal ethics compliance issues. As opposed to maybe the perception that you don't worry about if it's Rocket Lawyer or if it's simply if it's a network of smaller firms that just use technology to work together, then they have the basic conflicts of it. Jerkwad. So the Rocket Lawyer and Avvo, they're just really marketing platforms. I guess it would be how I'd categorize them. They have a lot of content that attracts people, both lawyers and prospective clients, to come to their sites because they've worked on that for years. And so the next logical step from their point of view would be to put the two together. And, the lawyers are really the ones paying, I guess. I guess there are models where the clients actually pay, or the prospective clients pay, and the lawyers don't. There's been a variety of these over the last 5 or 6 years that work differently, but they're just in the middle, at connecting people that are lawyers with people that are clients with legal problems. Okay, so different ways of looking at what a virtual law firm is. One of the reasons why this is possible, I think, is because the technology that's available today is far more sophisticated than it would have been 20 years ago or even 10 years ago, and generally a lot more reliable. And so I wanted to just sort of talk about a few of these things, which I think there's a variety of impacts of this on the legal community. Some of it levels the marketplace of the playing field because things are less expensive. In other cases, the technology allows you to do things you just couldn't do, in a traditional law firm with the technology 20 years ago. So I just wanted to take a few minutes to explain some of that. So we're in Second Life. Obviously, we can sit down together virtually and have a conversation. That didn't exist before Linden Lab created it. Really, in 1990, you wouldn't have something like this. And so this is a way for people really from all over the place, all over the world, to be able to interact with each other. Maybe not the most reliable platform, as our first 5 minutes of this presentation this morning kind of illustrate that sometimes the tech doesn't quite work right. If you're not, perhaps you're more sophisticated than I am in terms of setting it up properly. But nonetheless, I mean, this exists today. Skype is kind of the other, just sort of video conferencing that's essentially free. 20 years ago, really only very large companies could afford the technology to do video conferencing, kind of a live feed, because of the extreme expense of the software and hardware, but also the bandwidth availability in 1995 is very different than it is today. So those are both things that permit you to talk with people pretty much wherever they are. And there are other technologies out there that are similar, that are either free or low cost, that provide a way to communicate with people that really is very different. And much more, I think, more than a phone call, which is what the traditional interaction would have been in 1990. With regards to legal research, so the legal databases that exist are proprietary. And it used to be really Lexis and Westlaw were the two big companies that had control of that information. And so you would pay a lot of money in order to have a subscription to one or both of those services. What's interesting about that is some of the stuff that they provide to you is public domain information. I mean, any court opinion, federal or state, is not owned by anybody. It's a governmental publication, so it's free. And that has become increasingly available on the internet from those sources, rather than having to be collected by a West editor or a Lexis editor, which is the old schedule, the old way of doing it. Because of the internet, there are a lot of other legal research tools available. May not be as reliable, may not be there tomorrow. I mean, there are a lot of other issues with that. But rather than having to spend tens of thousands of dollars a year on Lexis, and that's the only choice you really had, you could use Google Scholar and basically get any case across the country or in the federal system for free. And it's relatively current. They don't have cases from the 19th century typically that are available to read, but it's basically Google's search technology tied to, essentially a free set of databases of court opinions that are indexed within Google Scholar. And there are other kinds of things that Google and other search engines have indexed today that are available more or less for free, or at low cost. Fastcase is an example. That, as a State Bar member here, that's actually a part of our State Bar membership dues to have access to basic Fastcase, as a part of a bar association. And again, that gives you access to case law, that you can search. I don't use Fastcase that much, but it is effectively free to me and a number of State Bar members in other states that have a relationship with Fastcase. I could go on. There's lots and lots of other free or essentially free websites today that offer legal research or legal information, whether it be case law statutes or some of these other databases that traditionally were only available through Lexis or Westlaw. That changes the marketplace because more people that are practicing attorneys that have legal questions can refer to these without having to have a really expensive subscription. And I think that that militates against having to join a big firm to have access to the same kind of information. Third thing that's on the bullet here is cloud computing. So this is just basically hosted service providers that provide application hosting. Clio is an online practice management system which lets you keep track of your billing and your accounting and your time management and all the rest of that stuff. It's entirely online. They're actually a Canadian-based company. They have a data center where your data is stored, and you don't have to have a expensive practice management system locally. Even though I still do, I still use QuickBooks basically for part of my practice. But you know, in the old days, I think your choice was to implement a relatively proprietary and relatively complicated system to manage a law practice. Where with Clio, I mean, you know, for probably $10 a month, you can basically manage your practice from it and send invoices and all the rest of it. And they're not the only ones. There's dozens, really, of cloud computing-based practice management vendors that are out there. Many of them at subscription basis, many of them very low cost without the significant capital expenses up front that a more traditional and maybe I'm wrong that it's not $10 a month, but you know, it's not, you know, $3,000, $5,000, $10,000 up front in order to buy a system and implement it and then maintain it. They're relatively inexpensive, comparatively speaking. And of course, email is today really a cloud app. Whether you use Google Apps or Google Apps for Business, or you use Microsoft's Outlook.com, or you use some other service. Many email providers today are really cloud-based, web-based systems, and that's been the case for a long time. Email, of course, in the 90s, you really, you know, you had to implement locally, you know, the hardware and configure it and have an internet connection and the rest of it, or pay somebody a lot of money to host it for you, where, you know, again, these services today are much less expensive for an email address that's, you know, not just like at yahoo.com, but a, you know, a legitimate your domain name kind of commercial class email account. One of the things I talk about in a little bit more detail in the article, it has to do with marketing and really advertising. Google and Bing, which is really what Yahoo is using underneath the Microsoft search engine, both provide a way for you to do online search marketing using keywords that trigger your ads. And there's an auction system that has an algorithm to let you bid up to a certain amount per each click, or, you know, per number of impressions. And there's a variety of other ways of dealing with it. But it really it is a way to directly market based on keywords for people that are searching the internet for things that are related to what keywords you're interested in or what you offer as a service. It's different than traditional marketing in the sense that if you were to take out a like a television advertisement, or you were to do a newspaper advertisement for your practice, the Baltimore Sun will charge you anywhere from $10,000 to $20,000 for you to appear as a full-page ad on the back of the Sunday edition of the first section, just one time. Very expensive. I mean, their market penetration is hundreds of thousands of households in Maryland, but nonetheless, it's one time, one ad. Very expensive. When I had talked to a local television station about advertising with them, their budget for me, which was to run a bunch of ads that were 15-second ads, I think, at like 5 o'clock in the morning and 6 o'clock in the morning, really off time during the news, basically. Their 3-month budget for me was around $10,000, and I'm just a solo practitioner. And I'm sure they engage in variable pricing and have higher prices than that. But 10 grand was kind of what they're talking about, which included the production of the television advertisement. And, you know, that channel probably reaches, again, tens, maybe hundreds of thousands of people in the metro area, maybe more. You know, they may reach out millions of people in Maryland and the surrounding areas. But very expensive. And also really hard to measure the impact. And that's really been, I think, a legitimate criticism of that kind of advertising, is it's incredibly expensive. And it's really hard to know whether people actually saw it, and that's the reason why they came to your firm. It also runs in the face of what many attorneys would say their predominant way of marketing is either through referrals from clients or word-of-mouth marketing through existing clients. That's their traditional, relatively low-cost way to market. So it's not usual, it's not typical for a firm to have a big advertising budget. And, you know, with 2/3 of lawyers practicing in small firms or as solos throughout the United States, most don't have the budget in the first place. The many hundreds of thousands of lawyers out there that are perfectly competent, they just can't afford to do traditional marketing or traditional advertising. What's interesting about Google, in my mind, is you could spend, $10,000 or $100,000 a year if you wanted. I mean, they will permit you to spend as much as you like, but you can also limit your budget down to what you can afford. I mean, you may not get the same ROI. Maybe you need to actually spend $1,000 a month, and 200 isn't going to do it. But you have a lot more control, and you also have a lot of data and feedback on whether your ads are effective, whether people click on them or not, and then you can measure whether they actually call you from there. That's a part of the data that's available to you through a service provider like that. And so it's very different, I think. It's a very different model. It's almost targeted marketing, in the more traditional sense. And it lets you really control and tailor your budget and try stuff that it would be very expensive to do the same. If you had to make 9 different television advertisements and see which one worked, I mean, you had all the production expenses of that you'd have to pay for. Whereas with this, you can have, in a day you could probably generate hundreds of these little click-through ads and tie them to particular keywords, and you're done. And you can collect the data and see whether it works or not, and which ads are more effective. That's the ones you want to run in terms of getting people to come to your website and buy services from you. Some other things that are more recent. There are secure websites, that is, websites that are encrypted between the user and the website provider. That some are more sophisticated than others, but they permit, in some cases, the way to provide discrete legal services to people. I'm actually a direct law subscriber, and if you go to my website at faithatlaw.com, I'm actually offering legal documents for sale. You go through a process to complete the document, to put in the information that's required. I review it, and then you can have a will, or you can have a power of attorney, or you can have a shareholders agreement. There's a variety of legal documents that are available through that site that's encrypted and secured by passwords. So that it gives you the ability to do that. And I suspect that Rocket Lawyer is basically doing the same thing. That they permit people to purchase legal documents, or just an hour of legal advice or something, from an available lawyer that's got skills and I assume is admitted to practice in that state, to provide that advice. So that's kind of a relatively new thing. I think the direct law people have been around maybe 5 or 6 years now doing what they do. Rocket Lawyer is a little bit newer, but I think Total Attorneys is probably a similar kind of service. They've been around for a few years as well. So again, a different way to buy legal services. If you need a will and that's all you need, then you can pay $150, a couple $100, get that document drafted up and available to you electronically. And then deal with the formalities that are required from there. A lot of attorneys travel are not as much in the office, not as much tied to a brick and mortar office, and obviously iPhones and Androids and Samsungs and all these other smartphones have really enabled you to have a pretty powerful tool that lets you work remotely or really work wherever, which I think Sam and I talked about that a couple months ago. That's both good and bad because you're really 24/7. There's no not here, not in the office, but nonetheless, it makes you a lot more portable, and it makes a lot more available to you electronically, beyond just your email and messages and phone calls, but internet access and access to web-based services and technologies that you can practice with. Besides Google AdWords, of course, there's directory sites like Avvo, LinkedIn, others. Avvo is specifically targeted to attorneys and I think physicians. LinkedIn is a more general kind of directory site, but you can find my profile there on both. Both of those sites, and there are others. At some of the older ones, there's a Lexis product that is basically a directory site. that they offer through Martindale Hubbell. Again, these are kind of basic sites that you can set up and make available. Not something that would have existed really electronically, in the 1990s. I guess you would have been limited to being in a paper book. I know the State Bar here still publishes a paper book of all the lawyers in Maryland that practice here. But I think that there's a whole lot of traffic today that goes to Avvo and LinkedIn, which is why they're around. And LinkedIn recently went public. There are many millions of dollars in revenue from them from advertising and other things. I think they had a $2 billion IPO, and there's clearly a lot of traffic to their site for people to invest that kind of money in a business model like that. And then some more traditional sending a newsletter. Of course, that was a paper thing, and there are lawyers that, in fact, do write paper newsletters. I haven't seen any in a while. Mail them out to your former and current clients or people that you want to keep in touch with. MailChimp's a free email newsletter service, and there's others out there, of course, up to a certain limit of messages that you can send. But again, another thing that's available technologically, today. And I think that when you put all this stuff together, what you get is a picture of a whole bunch of tools that are available, many at very low cost. The directory sites essentially are free. Newsletters can be essentially just your time to write them, and they are free. Going back here, there's a variety of legal research tools that now are much lower cost or potentially free. Email from Google Apps could be as little as $5 a month. I mean, it's almost free to have a commercial grade email presence. Skype and Second Life are both essentially free. So there's a lot of low cost or no cost technologies that let you do things that lawyers traditionally would have to pay a lot more to do. And I think that it's been the positive side of the technologies. It makes it easier for you to practice law, to be more efficient as a practitioner, and be less required, I think, to work, from a capital standpoint with a whole bunch of other lawyers in a firm that, pull together resources to pay $100,000 to have a website or $100,000 to do something. You don't need that kind of capital or that scale of capital to get started. So it's easier to get into the marketplace. I guess one of the other things is if there are more lawyers available that have lower overhead, then potentially there is more availability of legal services and I guess potentially a lower cost point or flat rate legal services, which was not the traditional way 20 years ago that firms would deal with clients. It was really an hourly fee. The idea of flat fees or limited fees is more possible today. If you can reduce your expenses and you can do enough volume, then it's possible that you could still make a reasonable living as an attorney. I guess the other side of that is that from a competitive point of view, people that were making a living in a traditional manner would have a harder time as the technology kind of changes the marketplace. Theoretically, it should be easier to find an attorney today. I mean, if you think about the Yellow Pages from 25 years ago, which is a traditional way that lawyers marketed, there were probably hundreds or thousands of lawyers in your region, and they were in the phone book. I don't know what you did to pick one. I guess it was whoever randomly you found. I don't know that's the most efficient way to find an attorney. With regards to networking with other attorneys or getting referrals or building referral networks, for one thing, those take years potentially to develop and really to get a referral network for a service that you're offering, get your name out there. But not necessarily efficient. I mean, there's probably a few connectors out there that are attorneys that know everybody else. And if you know that person and you're a client looking for a particular lawyer, maybe that's the person that they can find right away who you need to get to. But I can tell you, I mean, there are plenty of times that I get a call from a client that's talked to a bunch of other people, and they keep getting passed around because no one knows where to send them. And I don't know why that is in particular. It's the legal issue or whatever, but it's kind of an inefficient way to get clients connected with lawyers. So I think the technology, some of these marketplaces do have at least the theoretical possibility of being more efficient for people to find attorneys quickly, depending on what they're looking for and what the attorneys know about, rather than having to deal with lots of different people or get passed around or just end up with the wrong attorney altogether. This technology permits potentially to be more efficient. But I think that the other side of this it really comes down to the legal ethics rules. And I'm going to talk about just three. I think there are probably others involved, and there's other laws that are applicable. So, for example, it might be against the legal ethics to make false or misleading statements, but it's probably also against federal law, when you're advertising to consumers and you make false statements. So there's other statutes, there's other considerations than just legal ethics. But I think legal ethics is a particularly complicated area for a variety of reasons. And I want to talk kind of in general about what I think some of those are. One of them is that legal ethics itself is not, I don't think, a really well-known area of the law. We're all charged as attorneys to know what the legal ethics rules are. But, in Maryland, if you want to actually get the ethics opinions, which are not binding, but there's an ethics committee that writes them, they're not generally available. You have to be a member of the voluntary State Bar Association to have access to them. They don't really help you if ultimately the Court of Appeals here decides that the legal ethics opinion was wrong and they sanction you anyway, because it's up to the Court of Appeals ultimately there. So they don't shield you from liability if you comply with them. But on the other hand, not being able to have access to something basic like that in the state, unless you're a state bar member, and it's not being admitted to practice, it's the voluntary state bar. If you don't belong to that association, you don't have access to the ethics rules or the ethics opinions. So it's sort of a strange attitude when you're supposed to know the stuff, but yet not make it generally available. I mean, I think their perspective is to incentivize attorneys to join the voluntary bar. But just starting out, I mean, it's confounding to me that that's the case. The second thing is that, I mean, the other source of information besides the published ethics rules themselves, which vary from state to state, in spite of the fact that there is a model code that the ABA has published and that most states have adopted parts of, that's not the end of the story, for one thing. But also, it's interpreted by the court system. And unlike other court systems or other civil matters, you have a trial here in Maryland at the circuit court level, and then you have one appeal to the highest court. There's no interim appeals or appeal of right. And so it's up to those judges, basically. They have final say based on whatever facts were adduced at trial. And so unlike other sorts of situations where there's more litigation, more appellate or interim appellate opinions, this is really, I think, a lot more limited and not unusual. That states have kind of a short way to the highest court to get a quick answer on whether the attorney should be disbarred or not. I think the problem with that is that, frankly, you're more likely to get disbarred. You have less opportunities to present your case, for one. And it doesn't really give an opportunity for development of an area law, like contracts would have that kind of development. Or First Amendment litigation, which is very extensive, or criminal procedure, which is very extensively litigated, very well-known areas of the law. I think this is kind of on the sidelines, And no one wants to be the case. No lawyer wants to be called before bar council and have to defend themselves before the Court of Appeals. So it's very, I think, very negative. And that leaves a lot of open questions that in other areas of the law probably would get answered more quickly because of the litigation process. Second thing is that technology changes much more quickly than the ethics rules. And there are a lot of new technology providers that show up that market their services, but there's not an easy way to necessarily know whether they're ethically compliant or not. Part of it's the ambiguity of the law itself. Part of it is the lack maybe of access to opinions. Part of it is it's ethical in one state, it might not be in another. So they create, I think, a lot of complexity when you have a new technology, and I think it makes lawyers hesitate to adopt some of the stuff because you don't want to be that guy that has to confront an angry Court of Appeals thinking that you're taking advantage. And that's also true, Alan, that the investigations are confidential, and ultimately, if they decide to not bring charges, you'd never know. So there are a lot of investigations, I don't know how many in Maryland, but relatively few actually become reported Court of Appeals opinions. It's a wide range of things, so it's sometimes hard to even categorize what the priorities are of Bar Council or the Court of Appeals. Who are they really protecting exactly? So that you might have a sense of whether this works or doesn't work. I think there's a variety of these problems. You're trying to, they're not new problems. I mean, lawyers deal with this on a regular basis, trying to apply old statutes to new issues. There's plenty of situations you have to litigate because you don't know the answer. You're not sure what's the fairest answer to it. So I'm not saying that this is unique, but I think that this is more like the backwater legal ethics questions than it would be front and center, hot, sexy kind of law that people want to practice. And I think that makes it harder to predict what the issues are. These are 3 rules I want to talk about. All lawyers have confidentiality obligations. There are actually attorney advertising rules in the Maryland rules and in the ABA model rules, so I'll talk about that briefly. And then 5.5, which is the unauthorized practice of law when you practice in a state you're not admitted to, and what the rules are about that, and some of the issues, the technology issues with that. So this is what the lawyer ethics rules on confidentiality basically say. It's very strongly worded. The exceptions in paragraph B in our code are relatively narrow. Generally, it's to prevent the lawyer services being used for fraud or potentially to prevent a crime from occurring. You might be able to break confidentiality. The exceptions, though, and if your court asks you a direct question in open court, you're kind of stuck with regards to dealing with the rule, I think. But the general rule, and it's a very strongly worded rule, is you keep your client's confidences confidential, and you don't disclose them unless they give consent or it's implied in the scope of your authority to deal with the issue that you're trying to deal with for the client. But I think there's an enormous number of problems with this. Most of the technologies I've talked about are digital. They're not face-to-face interactions. So they're either through a website, or they're over Skype, or here, or they're through some other kind of service, and there's people in the middle of those things that are other entities that you may not have much control over, or that have a standard terms of service that may or may not deal with whatever your legal issues might be. There is a question, I guess, that comes up, which is whether when you communicate with clients through any of those new media, is that a breach of confidentiality? Is anyone listening that isn't you or the client? And I don't think that it's just conspiracy theory, because we became aware of what the NSA was doing through Ed Snowden's disclosures, and to the media, and then subsequently, if you read Glenn Greenwald's book on the Snowden revelations, you have a massive and extensive surveillance system that was built by the NSA that is collecting a whole lot of stuff from a whole lot of places. And that includes lawyer communications with clients. I mean, your emails, the content of your email almost certainly is being made available through the NSA in a database and could potentially be searched. Now, I presume, that on an average day that the NSA is probably not terribly interested in what I'm talking to my clients about. But you could imagine, for example, if you had a client that was in fact accused of terrorism, that it might not be such a great idea to be using email, Skype, Second Life, any of the systems that were being surveilled. And there were a lot of them. If you used Outlook.com or Google, there was a good chance that there was direct communication with the NSA from those vendors. Wherever you went on the internet potentially could be recorded and put in that database. And even if you used a traditional phone line or a cell phone line, calling someone else in the U.S., the metadata about those phone calls was being collected. So they would know that you had talked to a client and then that client called somebody else, and how long the phone call was. If that client happened to be not in the United States, then they probably recorded the phone call, regardless of what the phone call, where it was placed. And we weren't the only country doing this. Of course, China has a similar scale of surveillance. Other nations, Canada, our allies do this. We do it to each other. And so there's a variety of spy agencies that have access to this. Are they breaking our confidentiality? I don't know. I mean, the short answer is I don't know what the consequence is of them having a database with trillions of transactions in it. It doesn't make me comfortable or confident that that the information that a client shares with me in any of those forums is confidential anymore. It's a separate question of whether I'm liable for that. And I don't know the answer to that either under the legal ethics rules. I don't know that that's simple, to answer a question like that. I don't think there's been any litigation where a client sued an attorney because their conversations were actually recorded by, the NSA, and the NSA had access to them. But if this is going on, I mean, I also say here, it's not just the NSA. I mean, we've had before all this, or concurrently with this, there's plenty of people that break into law firms electronically, and use computer viruses as an alternative way to get access to confidential information, or just simply to destroy those systems through viruses that are destructive. And law firms are higher profile today. Probably bigger firms are the highest profile in terms of having a lot of information that would be of interest to criminals. But we all are affected by this. The keyloggers that the NSA uses to do surveillance on select computers are the same kinds of viruses that are in the wild that are installed by malicious people that want to get your passwords and your social security numbers. And if you think about it, if you act as a trustee for trusts in an estate planning practice, you have access to a lot of bank account information of accounts that potentially have large sums of money in them. You have access to high-value clients and their confidential information, their social security numbers, their bank account information potentially. All that stuff is very valuable to somebody who's a crook. And there are a lot of threats to us, to the confidentiality of that information, and potentially an obligation to report a break-in. Because there's a state law that may require you to report that if it's of a certain level. To report that. And I don't know what happens to you then. I think you have the risk of being disbarred under the confidentiality rules, depending on what your conduct was, that either prevented or caused something like that to occur within your control. I guess that I don't have all the answers today on what you're supposed to do or what not, or to have a lot of details about a plan. But I think there are a lot of open questions that need to be considered. One of them is when you should encrypt, whether encryption should just be a standard for all communications today, particularly in light of the massive surveillance that's going on. Should all of your client communications, is that the new standard of care that's required? I'm not saying it is or that it isn't. I'm just saying that maybe today the technology presents this that even maybe 5 years ago did not. I think that in the past you would look at encryption for particular kinds of clients. Someone that was international, maybe that was in fact accused of high-profile crimes. That's the kind of high-profile case where it makes sense to encrypt everything. But even to now, I wonder whether it's much more broad, and really to be serious about the privacy and confidentiality of the secrets that you have from your clients. I think it's an open question. Can you use these open systems, or the business class versions of them? And it's more than just reading the terms of service, which is what some bar counsel have suggested you should do and negotiate them. But I think it goes beyond, can you trust these people? They really don't have the kind of obligation of confidentiality that you have. And their contracts will say that there are exceptions to protecting your confidences and privacy that are based on the law. And if you interpret the NSA's actions as lawful, then they have an obligation to turn the information over. Or if a FISA court orders them to, as FISA did, to a telephone company, for example, to turn over the metadata. There's a legal process at least around that. Whether it's right or not, I don't know. But you have that kind of open question then of it's cheap, but the other side of it is it really confidential? And then I guess probably the answer to the last question is yes. I think this is probably what most attorneys would do. Is it depends on the client what's reasonable security, but my fundamental feeling is that the more that this has been revealed to the public, the changes our duty of care under the legal ethics rules, and it may very well change our perspective, unfortunately, on some of this technology that is available to us. With regards to the advertising rule permits certain kinds of advertising. What's funny about this list, at least in Maryland, is that Google ad keyword search is not listed, websites aren't listed, blogs aren't listed. They're not in the list. I suppose you might lawyer this list and interpret it such that you would include them. And I think there are probably ethics opinions that say that websites and other sorts of things that may be advertising that are web-based fall within the permissions here. What's important about this, though, is Rule 7.1 says no false or misleading statements. Generally, I think you probably should not be guaranteeing results for clients, regardless of what it is. And you probably have an affirmative duty to correct errors and mistakes in advertising. One of the other requirements is that an attorney, actually their name has to appear somewhere on advertising material. And Google AdWords is 3 lines is probably 100 characters. So you have a question of how you comply with that if you do Google Ads. My suggestion might be that you have a domain name that you use to advertise that has your name in it. That may not be the most SEO way to do it, but that may be the way to comply with that particular requirement. But each one of those things presents a question of how you go about complying with the advertising rules. And you have a record-keeping obligation. For the last 3 years, you're supposed to keep track of all your ads and keep a copy of them. So if there's a complaint about something you advertise, that you can then present it to bar counsel. But you have an affirmative duty to do that. With paper ads, that's simple, but with electronic, you probably have to do a little bit more planning to keep all that stuff in one place so it could be easily produced on request or demand. One of the other things that I've always thought a little bit strange, but is a ban within the rules, has to do with real-time communication with prospective clients. And the rule is set up in such a way, I guess it's the old ambulance chaser. They didn't want you running after some ambulance with some person that's injured in the ambulance trying to go to the hospital, and you giving them your business card saying, "Call me because I do big truck accidents." That was the kind of real-time communication that might, that the Bar Council is concerned about. But when you think about real-time chat, if you think about Second Life, which is real time, we're here in this room together in our different time zones, but having a real-time communication. Is it advertising? If I'm talking to you in a specific enough way about what your legal problems are, or I'm soliciting you for pecuniary gain in real time, and you're not another lawyer, and you're not a family member, or whatever the exceptions, the narrow exceptions that are listed in that rule, then you could cross the line of the advertising rule and do something that you're not permitted to do. And it was a lot harder to do because you had to do it in person 20 years ago. Today, I think the technology, for better or worse, makes this a lot easier, to communicate in real time. And, there is a prohibition on soliciting employment for legal services from somebody that needs legal services in real time. That rule, I think, hasn't been modified, and that I think has an impact directly, in terms of, us using technology as virtual attorneys. And so, here's the problems, and, what is an advertisement, which is not clearly defined, I don't think. What you traditionally think of as an advertisement may or may not apply to every other thing that you do. Blog entries, I think, are usually not looked as advertising because they're not really specifically aimed at someone. But then you could write them in a way that they are. So, I think it depends. Unfortunately, there's not a clear rule about that. And, again, dealing with record keeping, dealing with false or misleading claims, correcting errors, and dealing with record keeping are all problems that, have all these administrative burdens. So easy to get on Rocket Matter, complicated to deal with all this stuff, I think. And then finally, I know I'm a little bit over time, but I just want to end with this last ethics rule, which has to do with the unauthorized practice of law. And I think this is actually a lot harder in terms of compliance than the advertising rules might be, and even maybe the confidentiality rule. And the reason for that is that what is the practice of law is not self-defining. It's actually defined by state law. And the states don't agree. And let me just, for purposes of reference, let me just post this first quote from a case in Ohio. The Ohio State Bar Association v. Miller came out in 2014 at 138 Ohio State 3rd 203. And they talk about the rendering of legal advice, preparing legal instruments, preparing and filing legal pleadings, appearing in court, managing actions. But then you notice down here that they say, in other words, it includes all advice to clients and all action taken for them in matters connected with the law. I think the Ohio people have an extremely broad definition of what the practice of law is. That is different, and I think meaningfully different than if you look at the statute in North Carolina that has to do with the practice of law. I don't think that that they're saying that the only time you're practicing law in North Carolina is before a court, preparing legal documents. There's a different way, but if you think about that, that means the North Carolina Supreme Court has a different interpretation of this than the Ohio Supreme Court. And every state defines what the practice of law is and therefore what the unauthorized practice of law is. So if you were to practice in 50 states, you would have no idea. Unless you're admitted to practice against in every state, which would be an enormous number of bar exams and CLE requirements. One thing that might be the practice law is not a practice of law in another state. Washington State has certain exceptions. For example, for real estate closings is not the practice of law. It's kind of ambiguous, or probably is the practice of law in Ohio because there's no exception to that. Preparing legal documents and talking about what they mean. Sounds like that's legal advice in Ohio, but Washington has specifically carved that out. This is really difficult. So when you're committing the UPL, I think that's equally difficult. It's easy to say I'm practicing law in Maryland where my license is, but it's less clear when I'm practicing law in another state because it depends on what their definition is of it and what really the litigation has suggested it is over time. In 2000, the ABA attempted to develop a model definition of the practice of law, and it was roundly criticized when it was published as enormously broad. And there are actually federal and other agencies that heavily criticized it for including things in it that traditionally have not been considered the practice of law, like form libraries and just documents that are available on the internet, for example, or in form books. Probably would have been covered as practice of law under the ABA model. So there isn't a consistent definition. The response from the ABA at that point was, okay, we'll just leave it up to the states. We'll leave it where it was, and you have a wide variety of what it means. I haven't read in detail the LegalZoom litigation, but they've been sued by a variety of state bar associations on allegations that they, in fact, are practicing law, and they're not lawyers. They're a forms company or a web-based forms company, and they've litigated that. And they have actually, I think, won in several states. For example, Pennsylvania, I think, finally concluded what they're doing was not the practice of law. But there was a lot of uncertainty, with regards to that. And they haven't litigated in every state. I don't know what would happen in Ohio. I'm not aware of a case there that has concluded one way or the other what they're doing amounts to the practice of law. In the context of a virtual attorney, if you think about it, in Lincoln's day in the 19th century, what did lawyers do back then? They opened up a law practice down from the courthouse and they litigated cases. And it was pretty clear that that was lawyering and that stuff that wasn't that was not lawyering. And that's how you advertised. I mean, the chance of Lincoln having a client from California was very low because, for one thing, who'd ever know him until he became really well known? Nobody. Just his railroad clients and the people that knew him in his state. So UPL issues 100 years ago, relatively few. Or they were limited to people that clearly never had a license in any state to practice law and were actually going to court, or doing things that were clearly law. Today, there's all these services where you can find clients. They're not necessarily filtered by state or by your license. They're generally websites that are national or international. And we confront that here at the Bar Association when people have legal issues. I can't help just anybody. My license is limited. It is not just in any state that I can practice any old kind of law. The model rules do provide a multi-jurisdictional rule, and there are exceptions that permit certain kinds of practice in other states with a single license. So, for example, when I process trademarks before the U.S. Patent and Trademark Office, their requirement is you be an attorney admitted in any state to process trademarks. That's federal law. It's a federal registration process. So, that isn't UPL, I think, is a fair reading of that rule. But there's a lot of things that might be or that are on the line, and I think it's a lot easier to meet clients from outside your jurisdiction with issues that are not really in your jurisdiction, may not really be governed by federal law, and that you have a much easier time of committing UPL. It's just that much simpler to do. I think it takes more filtering to safely avoid charges of UPL. Yeah, agenda. I mean, I feel the same way. That gaming is a great example of a really complicated legal issue that there are not that many attorneys that can advise on it in the first place, but it's not just simply a matter of federal law. It's sometimes a matter of international law. It might be a matter of state and federal law. So it actually it's a very complicated issue, and I would not go out of my way to say that other attorneys are engaging in unauthorized practice of law and to come to a legal conclusion like that, but I do hesitate, in terms of people that were in fact writing reasoned legal opinions, whether they really were admitted to practice in any state or in an appropriate state in order to give that kind of advice. And yeah, I don't know, Jerkwat. I mean, if I was in Ohio, I don't know whether this is legal advice what I'm giving here. I make legal presentations on a pretty regular basis, and no one's complained to bar counsel about it yet. And I'm not the only attorney that does stuff like this, sort of general legal information. But it's very easy even here, to cross over and start giving you legal advice directly about your particular legal issue, and the conversations like that happen on a pretty regular basis, in my observation, because people do have questions, and you try and answer them. But the more you're asking me about your particular legal situation, the easier it is for me to cross over to actually giving legal advice. And it might also be UPL. I mean, it creates all kinds of problems for the lawyer. To have basically have a client that's not paying you, and then on top of that have legal obligations, confidential obligations to them, and then potentially be giving them advice outside of your jurisdiction or your licensing. It's like the trifecta of you don't get paid, you might get disbarred, and by the way, you might be committing UPL, which is illegal. It's actually a felony in Florida, I think, and at least a misdemeanor in Virginia. So you could go to jail. It's like, really? And the technology makes it a lot easier to engage with people, but then it creates enormously complex legal ethics issues that do not have a simple answer to them. So I think that's my last slide. I don't know. I know I'm a little bit over time. I don't know if there's any other questions from folks here. Yeah, I agree, Agenda. It seems like we're overly lawyerly when we say stuff like that, but you read the ethics rules and the opinions, and you see the people that get disbarred, and you wonder, where the line really is. I think that, like all things in business, you do have there is a risk assessment you have to do with regards to practicing law and marketing for law and these other things. I think that it's a very hard risk analysis because, in part, the legal ethics rules are really not very clear, and they've not been adjusted based on the technology as it comes out. Even technology from 10 years ago, there's still, I don't think, an opinion about Second Life, whether it's you have people running around in this world doing lawyering as a role play. Is that a violation of UPL? You have a role-playing lawyer who is providing real legal advice to people outside of his real-life jurisdiction. Is that UPL? Is that a violation of the ethics rules? I'm not aware of anybody writing an opinion about it. Maybe it just doesn't matter to bar counsel, and that's the reason why it's not a priority. But this has been around for a long time here, relatively speaking, and there's still not really any clarity on that. So never mind some technology that's from yesterday or from a year ago. I think it's really difficult to do a fair risk assessment, but I don't think you can take no risk. You can't practice law today and not take risks with your license. I think you just have to take knowledgeable risks with them. and reasonable ones. Some people are a lot less risk averse. I think biologically, folks that are younger getting out of law school may be willing to take a lot more risk than those of us as we age, and it's just sort of a biological impulse. But I think even with a lot of maturity, that you still have to take knowing risks in order to practice. I just think that my presentation says, or my conclusion, I guess, would be that it's hard to estimate in some cases the risk because of the way this works, and I think that's a real disservice to lawyers. Because I think it would cause a lot of us to hesitate to help people that need help. And what are we here for? If it's just to protect our license, I'm not really sure why we would keep practicing. But that's not an easy question to answer. Any other questions or comments?